Welcome everyone to the Plan Documents Galore, Understanding the Differences and What's Required webinar. Thank you all so much for joining us. Our moderator for today's call is Jill Brooking. She will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to hand over the call to our speakers for today. Joining us today are Elizabeth Allen, Vice President and Counsel of Benefits Compliance at NFP, and RJ Lyelli, ERISA Plan Document Specialist at NFP. We're very excited to have them speaking with us today. It is my pleasure to hand over the call to our speaker. Beth, the floor is yours.
Thank you so much, Amber, and thank you everyone for joining us today to talk about plan documents. We actually presented on this topic back in 2020 at some point. All of us were in this twilight zone having to do with this global pandemic, I think. So we thought it a good time to come back and talk about this fundamental issue that we still see a lot of plan sponsors have a hard time with. And so today, as Amber mentioned, you all know me for the most part, but RJ Lyelli is making his GetWise Wednesdays debut as a member of the NFP Plan Document Operations team. And so welcome to RJ, and y'all go easy on him today. As always, this presentation, although given by people who might have a JD or are lawyers, is not legal advice or tax advice, and we're just basically providing informational guidance based on the benefits-related laws. Y'all are used to that. So I want to start off just because I think this has somewhat been a hit and given us an idea of who and what we're dealing with. We wanted to start off with a poll today. So the question for today is, how do you feel about the state of your plan's documents? Okay. A is we're all buttoned up, dotting every I and crossing every T. B is we've made some effort, but think things need to be cleaned up. And C is we don't know what we don't know. And so we'll take a couple of seconds. I will insert the Jeopardy theme song here while people get to answer. Thank you so much for everyone participating. We'll go another 5 seconds or so. All right, Amber, can we share results? Very good. So interestingly, 14% of you said we're all buttoned up, think everything is good. And for those of you who answered that, I admire you for still jumping on here to learn. Kudos to you. The bulk of people, over half, said we've made some effort, but do think that things need to be cleaned up, and that's a good place to be as well. And then there are other people who just said we don't know what we don't know. And so interestingly, in that third group could be members of both the first two groups, but you might just need to know kind of how you're doing, and this course should provide you with somewhat of a litmus as far as where you are. So thanks so much for filling out that poll. So now we'll go into the agenda for today. We're going to talk about very specific documents. We'll start off with cafeteria plan documents. We'll talk about ERISA plan documents. We'll talk about wrap documents, which is probably a phrase that a lot of you are familiar with. And then we'll end out with some distribution method conversation, as well as some final thoughts. Now, a caveat here, okay? This presentation is solely focused on health and welfare benefits. And the documents that are required for that, and kind of how the industry has solved the need to have plan documents for those benefits, okay? But a lot of you who are retirement plan sponsors as well also have plan documents that you have to have for those plans as well. Importantly, these are two totally separate sets of documents, right? And they're not appropriate for all employees, so you want to keep that in mind. But I will also say that on the retirement side, it's a little bit easier on plan sponsors because generally your fund custodian, or whoever the houses the money for your retirement plan, basically does your documents for you. So they draft them and they provide them, and it's really just up to you to distribute them sometimes, because sometimes they even distribute them. So keep in mind that today's presentation is focused solely on health and welfare benefits. So for each type of document that we talk about, we try to lay out kind of just an idea of what we're going to talk about. So with each of those documents, we're going to talk about which law requires the document, what the required content is, who has to receive the document as well as when, and then how often does the document have to be amended, okay? And then kind of a bigger part of our conversation is, I think, some of the pro tips and the common pitfalls that we find that employers, plan sponsors struggle with on the different types of benefits or documents, excuse me. So I'm going to kick it off talking about cafeteria plan documents. And interestingly, I wanted a graphic that had a cafeteria, and this was like the closest picture to a cafeteria, which I feel like is incredibly swanky and looks a whole lot different from the cafeteria that I feel like I grew up with at school. But that is supposed to be a cafeteria. And although the industry has named it a cafeteria plan document, we get this requirement from the Internal Revenue Code Section 125. And so interchangeable with cafeteria plan document would also be a Section 125 document. And really, it just requires a written document that incorporates the rules under Section 125. Section 125 specifically is the only way that we can allow for participants to pay for their health and welfare benefits on a pre-tax basis. And so if your medical, dental, vision, host of other benefits are offered and employees can pay their contributions on a pre-tax basis, then a Section 125 plan would be what you would have, and you would need a Section 125 plan document. Additionally, you can use the Section 125 plan to meet the requirement to have a written document for an FSA, or a flexible spending account, or a DCAP, which is a dependent care assistance program or plan. And so that's the document that you're going to have. And I think importantly on this one, you want to make sure that it's adopted on or before the first day of the first plan year. And technically, it also needs to be adopted before you actually offer pre-tax benefits. Okay. Now, some of you might be saying, oh, shoot, we definitely offer pre-tax benefits, but I can't say that I could put my hands on our cafeteria plan documents. You are not alone. And that's kind of why we are having this conversation. What is the required content? You see this kind of whole list of different things, and some of these things will look more appropriate or not appropriate, more familiar to you than others. But I will say that it's important when it comes to Section 125 or cafeteria plan documents to remember that when you see these are specifically having to do with the portion or the design of the plan offering pre-tax benefits. So it's not necessarily, let's say, the eligibility rules or the participation rules for the underlying benefit components. It's for the whole plan and the fact that you could take pre-tax benefits. And that's kind of an important but weird distinction to make. So I wanted to mention that. But you see all these things listed that you would expect to find in a cafeteria plan document. Additionally, although not required, there are other recommended provisions that we would that we would expect to see in this type of document. And so you want to make sure that, you see different statements about the cafeteria plan, provisions governing amendment, termination, administration of the plan are ones that we would expect to see as well. A provision giving the plan administrator the authority to potentially change a participant's election at certain times to kind of make sure that they don't fail non-discrimination testing. There's certain things that you're going to want to see in that document, even if they're not required. Now, who must receive the document and when? This is interesting because we see a lot of employers who are like, oh, we're going to give this out, but the IRS doesn't actually require you to distribute this document. You're really just supposed to have one and you would maintain it in your files, okay? Obviously, if the IRS ever came and knocked on your door and wanted to basically review your cafeteria plan, you would hand it over to them. Surprisingly, the DOL probably doesn't care about your cafeteria plan documents because Section 125 of the Internal Revenue Code is not under their jurisdiction. So this would potentially be the IRS or maybe other government entities, but not necessarily the DOL that's asking you for this. A participant can also ask you for it. And if they ask you for it, it's usually a pretty good, best practice to give it to them, right? Like there's not really any harm that it's going to do by you providing that document to the participant. And so you want to make sure that if they ask you, you fulfill that because there are other requirements that we'll talk about later where if you don't provide the documents, then it does become very harmful to you as an employer. And then also, we do have some employers who do choose to distribute the cafeteria plan document. One of my pet peeves is when you kind of combine, let's say, the cafeteria plan documents in with the ERISA plan documents that RJ is going to talk about, because technically those are two different documents, or at least two different sets of documents that have totally different purposes and mean totally different things. And so I definitely keep them separate from other plan documents if you are going to distribute them to participants. Now, how often must the document be amended? This is one of those documents that technically doesn't have to be amended on any required interval from the IRS. They didn't lay out that, you need to do your cafeteria plan document every year. So what we normally would say is that you're going to want to amend that document if there are changes to the terms that are in the document, right? So if you have a document and now has something that's incorrect, then you would basically want to make sure to update that document once you know that there's information in it that is no longer applicable. Examples of situations that would prompt an update would be, for example, if you choose to start recognizing or stop recognizing certain permissible qualifying events, which I'll talk about just a little bit later. If you make any changes to, let's say, the grace period or carryover options for your FSA or DCAP, then you would want to definitely update the document. Additionally, some of you might have basically created a Section 125 document back when your company only offered, let's say, medical and dental and vision. If later on you start to introduce other potentially pre-tax benefits, then you're definitely going to want to update those benefits or those documents to include all of the pre-tax benefits that you offer. So now, with that said, what are some of the pro tips and common pitfalls and just conversation that we would want to have surrounding Section 125? Mind you, the industry has created a couple of different solutions for different legal requirements that need to be met. And we find that with cafeteria plans, because some of you might be saying, well, I don't think we have a cafeteria plan document, but you do know that you have something called a POP, or a premium only plan. And a premium only plan, really the only difference between that and kind of, I guess, just a regular cafeteria plan. And I say that, but I mean, technically a POP is a cafeteria plan document, but not all cafeteria plan documents are POPs. But the whole point of a POP is that it's generally going to mean that none of the pre-tax benefits that are covered under the arrangement are reimbursement arrangements, right? And so it's generally just going to be pre-tax benefits for which the employee pays premiums on a pre-tax basis, and it wouldn't have any of these type of accounts like an FSA or an HSA or a DCAP that are not really premium based. They're actually reimbursement based, right? And so that's kind of the difference between those two concepts. Obviously, as it pertains to who drafts this document, often if you have an FSA or a DCAP, it's probably most appropriate for that vendor to potentially draft your Section 125 document, because they're already having to provide documents that meet the Section 125 rules, but for that FSA or that DCAP. And so it's generally going to be easiest for them to just go in and add all the other kind of pre-tax benefits into those documents than it would be to have, let's say, multiple cafeteria plan documents. Now, you can have multiple cafeteria plan documents, but then you just want to be careful and make sure that they don't conflict with each other and it doesn't cause any issues. I will also mention that, kind of similar to retirement plans, sometimes you'll find that a vendor's cafeteria plan documents include an adoption agreement of sorts. And so this is kind of a part of the document where you go through and you highlight kind of all of the different terms and provisions of your cafeteria plan and kind of check off what you're going to put in your plan and what you're not going to. And generally, if you have that process or that document with your vendor, then that should be considered part of the document, because generally the rest of the document that comes out may not reflect those choices that you made and may have more generalized language surrounding the procedures in place. And so you want to make sure that if you do have an adoption agreement, that that's included. I'll also say that sometimes, using, let's say, the run-of-the-mill, template of a cafeteria plan document is not appropriate, where you have certain designs that are a little bit different. So for example, if you have a cash in lieu of benefits, or if you allow people to waive and receive cash, then that is usually called a cash in lieu of benefits provision. And your plan needs to say that, right? Because Section 125 is actually the portion of the IRS that allows that, or the IRC that allows that, but it should also be in your documents. Likewise, if you are an employer that recognizes the qualifying event tag-along rule, then that might take special document in your or special provisions in your cafeteria plan document as well. My last thing, which is kind of a personal pet peeve of mine, is that your Section 125 document is also the document that generally is going to lay out qualifying events, okay? And so Your qualifying events obviously are what the events that the IRS has laid out that would allow for an employee to change their election mid-year, right? And so interestingly, some of those are required, and those are generally the HIPAA special enrollment rights, and some of them are permissible, meaning that the employer can choose whether or not they want to recognize those events. The documents work in here because usually I will say that most templates of cafeteria plan documents are written to recognize all of the permissible qualifying events that the IRS allows. Okay, but then sometimes we see that an employer's, let's say, benefit enrollment guide or other documents that are provided to employees, or maybe even their benefit admin system, doesn't actually reflect that all of those qualifying events are recognized. And so you want to make sure that kind of the list in the plan document matches, the list that you put in other documents, and that your benefit admin system is actually set up to reflect the fact that your cafeteria plan offers all of the possible qualifying events. So that's a discussion of cafeteria plan documents. We obviously have a lot of information today, so I think we're going to save questions for the end, but I didn't see that many come through. So with that, I am going to turn it over to our Get Wise Wednesdays newbie. RJ, you want to start talking about ERISA plan documents?
Sure. Thanks a lot, Beth. And hi, everyone. I hope everyone's doing really well today. Let's start it off by talking about ERISA plan documents. So what is ERISA? ERISA is short for the Employee Retirement Income Security Act of 1974. It's basically a federal law that is very comprehensive and which regulates employee retirement and health and welfare benefits. Today, we're going to take a closer look into the health and welfare side of ERISA. And when we talk about ERISA documents, we are talking about these 4 documents that you see in front of you. The plan document, the summary plan description, also called the SPD, the summary of material modifications, also called the SMM, and the summary of material reduction in covered services. Each one of these documents has a purpose and must also have certain content requirements, which we will talk about now. So the first one being the plan document. ERISA has a requirement for employers to maintain a written plan document. Basically, the plan document is a contract between the employer and the employees about the benefits that the employer is committed to providing to the employee. So it should include information about specific plan-related concepts so that participants and beneficiaries know their rights and obligations under the plan. And a good idea is to have this thing signed and dated and then kept somewhere in your files in case you need it. Because technically, if this document is not signed and dated, then it's not a valid document. And remember I said how these documents have certain required information that must be included? Well, ERISA doesn't exactly indicate what exactly needs to be put into a plan document the way it lays out specific pieces of information that needs to be included in the SPD, for instance. But the list you see right in front of you is what we generally like to see included in the plan document. I do want to say that before the ACA, the DOL wasn't really enforcing a lot of this stuff on health plans, so employers could easily get away with not even having a plan document and just having an SPD. But in recent years, there's been guidance from the Supreme Court where they said, basically, if you can't have a summary plan description that doesn't summarize a plan document. So it kind of makes sense, right? The SPD should be summarizing the information within the plan document, which is a little weird because there's a lot more required information that needs to be included in the SPD, but I'll get to that in a minute. So next slide. So who must receive this document and by when? So the plan document doesn't need to be sent out to employees or participants unless they request it. Remember that it's not valid unless the document is signed and dated. So it's a good idea to know where this document is, because if someone requests this from you, it must be provided within 30 days of the written request. And if it's not, you could be penalized up to $110 per day. It might be more now, actually. I'm not sure, but it's at least $110 per day. So it could be pretty hefty. Next slide. We are now moving on to the summary plan description, also called the SPD. This is an ERISA required document, and it's the primary document that lets participants and beneficiaries know the information about their health and welfare plan and how it operates. It also advises them of their rights and obligations under the plan. And then remember when I said that this is a summary of the plan document, this summarizes the plan document for employees and beneficiaries who receive the benefits under the plan. So it needs to be written in easy to understand language. That's a really important question that we ask ourselves when we're looking at the SPD. Will the average participant under the plan be able to read this and understand their rights and obligations under the plan? Similarly, when we write up the benefit eligibility charts that we include at the end of this document, that lays out the components of each benefit, we need to write it as clearly as possible so that employees will look at it and understand if they meet the specific eligibility requirements for participation, or when coverage will begin for them, or any other relevant benefit information that they should know about. The SPD actually requires 17 pieces of information, and we're not going to go through each and every one of those requirements, but this slide highlights a lot of those. And I do want to mention that the SPD does include important information that you just won't find in the carrier certificates. So for instance, in that first box right there, you see the plan identifying information. That relates to like the name of the plan, the 3-digit ERISA plan number, the name of the employer, the address of the employer, the plan administrator, the agent of legal service of process. And this, as well as other content included in the SPD, is very important information, and the participants should know, and that the basic certificate of coverage will not provide. Now, let's talk about distribution requirements. The SPD needs to be provided to any covered participant. Covered participants, I just want to say, are not just employees who enroll in the plan. They can be any COBRA qualified beneficiaries, any alternate recipients under any qualified medical child support order, maybe spouses and dependents or children for a deceased retiree if you do offer retiree benefits. Just remember, bottom line is that covered participants could extend outside of just your own employees. The initial SPD for a new plan or a plan that's newly subject to the SPD requirements must be distributed to all plan participants no later than 120 days after the plan is first subject to those requirements. The plan administrator must distribute the SPD and any summary of material modifications not yet incorporated into the SPD to a new participant within 90 days of enrollment. For existing plans, SPDs must be updated and distributed every 5 years if there are material changes to the plan, or every 10 years if there are no material changes. And I will talk about material changes a little bit later on, but just know that material changes would be viewed as any change that a participant would reasonably want to be made aware of. Also, SPDs likely should be distributed to a participant or a beneficiary who requests the SPD within 30 days of request. Moving on to the summary of material modifications and summary of material reduction in covered services. These are the ERISA required documents that supplement the RAP plan document and plan SPD. These are fairly self-explanatory, but when there are any changes to the plan, participants should be made aware of those changes, right? The purpose of the SMM is to notify those employees of the material changes to the plan, and the purpose of the SMRCS is to notify employees of material reductions in those benefits and services offered under the plan. Some employers just choose to update their SPD with these changes and resend those out annually, which will in fact take care of those SMM requirements, but If there's a material reduction in covered services, then the distribution requirement is a whole lot quicker and needs to be addressed as soon as possible. So if you see right in front of you, who must receive these documents and when, they're as follows. The SMM requirement for distribution is pretty lenient. You get up until 210 days after the end of the plan year in which the change occurred. So let's just say you have a calendar year plan and you decide to add another benefit to the plan or change carriers this year. Technically, you would have up until 210 days after December 31st of this year. So we're getting into the later part of next year. Now, the SMRCS is a little bit quicker. It's actually within 60 days after the change. This isn't 60 days after the plan year ends, but once that change actually occurs, you need to notify participants much quicker. And these are outside limits, by the way. So it would always be a good idea to notify participants and satisfy these SMM and SMRCS requirements as quickly as you can.
Thank you, RJ. So just to talk about really quickly, kind of what it takes and how often these documents must be amended. This is kind of an interesting conversation, and I think that it's one that's changed over the years with the advent of, like, obviously technology. When ERISA first started in 1974, everyone did not have a computer in their pockets in the form of a cell phone, whereas now we are used to getting the vast majority of our documents electronically. So that's changed what the amendment process has looked like for plan documents, okay? However, with the plan document itself, there are no required intervals for amendment on that one. It really should just be updated when changes are made, similarly to the Cafeteria plan document. And then as far as options on amending the SPD, RJ spoke to this a little bit, because you can choose to update the SPD when material modifications are made and redistribute that SPD at that time. Or you can provide SMMs or SMRCSs when amendments are made to the information in the SPD. The important part of that generally is that if you choose to go that second route, then the SPD now becomes the SPD documents plus those SMMs, right? And so when you have, let's say, a new employee who's coming in after you've made this amendment, they need to get both the SPD and the SMMs that have not been incorporated into the document. And we can't stress that enough because a lot of employers don't necessarily think about it that way. And so, RJ, I'm going to kick it back over to you to just start off talking about some pro tips and common pitfalls.
Sure. So some of the pro tips and common pitfalls we see, I just want to start out by saying what benefits are subject to ERISA. The benefits listed in green here in front of you are the common benefits that ERISA will always apply to. The benefits listed in yellow are sometimes subject to ERISA and therefore sometimes included in the wrap document. And the benefits listed in red are just not subject to ERISA and won't be included in the wrap document. So the benefits we always include, if they are offered, are the medical and prescription drugs, dental, vision, life and AD&D, also voluntary life and AD&D, short-term and long-term disability, voluntary STD and LTDs, FSAs and HRAs, along with some other types of benefits. Now, EAPs, employee assistance programs, could or could not be an ERISA benefit. It really depends on how it's structured and what type of benefit it actually provides. Think of the EAP as being subject to ERISA if it offers some type of medical care or service like mental health counseling, and it has trained professionals. If it's just providing a referral service, then it probably would not be subject to ERISA. Voluntary benefits such as critical illness, hospital indemnity, cancer, etc., as well as some other types of voluntary benefits are typically not going to be subject to ERISA because they likely fall into the voluntary plan safe harbor exemption. If the employer has any involvement with these benefits other than just offering them during open enrollment, such as contributing or allowing employees to contribute pre-tax dollars, which is rare, but I've seen it happen, then that will take it out of the exemption and they would be subject to ERISA. I just want to mention also that if you are treating these benefits as being subject to ERISA, then you should also be offering COBRA on those benefits as well. Lastly, dependent care assistance programs and health savings accounts are not subject to ERISA. They may be included in the Section 125 plan document that Beth talked about earlier, but they will not be included in the ERISA required documents. And this is also not a comprehensive list of benefits at all that are subject or not subject to ERISA. Like I can think of, for instance, commuter benefits. That's another benefit right off the top of my head that's not going to be subject to ERISA. But there are other less common benefits that I didn't include, but these are definitely the most common. And now, Beth, I think I'll let you talk about this slide right here.
Sure. So just to talk about a couple of common pitfalls that I think we often see and get in questions. Mind you, as quiet as it's kept sometimes, because I feel like people always feel this way, there is no size threshold on these requirements, okay? And so we are used to a size threshold on the Form 5500, and that if you have a health and welfare plan that has less than 100 participants on the first day of the plan year, you're not required to do a Form 5500. There is no size threshold or no such size threshold for plan documents. So that means your smallest of the small ERISA plan is still going to need to have a plan document, SPD, Section 125 plan document as well if they offer benefits pre-tax. And so keep in mind that like this is not something that anybody gets out of unless they're not subject to ERISA, okay? As far as SPDs, there does need to be one, right? And no plan automatically has one. I think RJ mentioned the fact that the carrier certificate is not an SPD. A lot of times the carrier certificates will even say this is not an SPD. Okay. And if you do, there are some carriers out there who might call their carrier certificate an SPD, but unless it has all of the required content under ERISA, it is not technically an SPD that is going to be recognized by the DOL. Okay. I'll also mention that retroactive adoption on SPDs or even plan documents is not allowed, right? So the idea would be that for a given plan year, you have until the end of that plan year, the last day of that plan year, to adopt a plan for that year. So with 2022, for example, if you have a calendar year plan, you have until December 31st, 2022 to adopt a plan for 2022. After that, you can't go back and do it, right? So like no one can now for a calendar year plan 2021, go back and adopt a SPD or plan document for 2021. It's too late, okay? Also, keep in mind that with SPDs, annual distribution is technically not required, as RJ mentioned, with a 5-year and 10-year, threshold, but it is appropriate if you don't want to do that whole SMM process, okay? And so we already mentioned that those are done in different ways. And I'll also mention that kind of because benefits laws like to kind of intersect sometimes, we also have a requirement under the ACA with the summary of benefits and coverage to where if the material change that occurs happens mid-year and it changes the content of the SBC, then you can basically just update the SBC and provide that to participants, and that would actually meet your SMM requirements. And so that's one thing to keep in mind as well. So RJ, you want to talk about a few more pro tips that you've kind of seen as you have gone through and created documents?
Sure. I will go over some special compliance issues now related to ERISA documents. So for existing wraps with 100 or more participants, the plan information, which includes the plan name, plan number, original effective date, and employer name, should really match the information provided in the prior Form 5500 filings. And why does this matter? Well, sometimes the government wants to look you up to see if you've been filing the required forms, and guess what? They will look you up and by plan name sometimes. It's not always going to be your EIN number, but sometimes it'll be the plan name or the employer name. When we create documents, sometimes I see the requested plan name is slightly different from what's listed on the prior Form 5500, or the employer name is missing an LLC or a period at the end of their name. And if you're missing even a punctuation mark in the employer name, you may not even show up when someone searches for you in the DOL database for your Form 5500 filings. So the main point is that the plan information should match exactly. And If the plan information does change, if you change the name, for instance, then that change needs to be highlighted in the next year's filing. Now, there aren't too many compliance issues I can really think of for the summary of material modifications and summary of material reductions in covered services, except for maybe like what is considered a material change. Remember that an SMM is required whenever there is a material change to the plan. Many people wonder what constitutes a material change, and that would be a whole lot easier if there was a definition of what a material change is, but there's not, unfortunately. The best way to think about this is that a material change is any change to the plan that a reasonable participant under the plan would want to be made aware of. So, for instance, definitely any benefits that are added to the plan, you would want to let participants know of those. Any changes to the plan year, or maybe carrier changes, or maybe some of the eligibility requirements or waiting periods for the benefits changed. And that would also be an example of changes that you would want the participants to be made aware of through a summary of material modifications. And lastly, the SPD should include the full eligibility picture. So for instance, if you employ variable hour employees and you use a look back measurement method to determine their full-time status to just see if they're able to qualify for benefits, then those employees may not be eligible immediately. This is information that the employees should and need to know. So look back information also needs to be explained in the SPD if you are using it. So that will include the specific dates you use for the measurement periods, the administrative periods, and the stability periods, as well as information on how eligibility is calculated. And as you can see, so next slide, please. Moving on to wrap documents. As you can see by the present on the right side of your screen, we are going to talk a little bit about wrap documents. Now, there's no law that actually requires this document, so you may wonder what exactly is a wrap document and why should I have one? Well, it's generally used by a fully insured plan to supplement an insurance policy or similar third-party contract by wrapping itself around the document and supplying the ERISA bells and whistles. So I talked about how some pieces of information that is included and required in the summary plan description, you will not find in the carrier certificates. The SPD is really not complete and should not be distributed to participants without the carrier contracts, policies, evidence of coverage, booklets, and or detailed benefit summaries related to each of the benefit components. Essentially, the SPD wraps together all of those important benefit-related pieces of information, along with any SMMs together into a neat little present of ERISA required information. And I'll let Beth, I'll let you take care of this slide.
Sure. So the wrap documents, it's kind of interesting because really these are an industry solution. And I kind of talked about that a little bit with the POP and the cafeteria plan. And really the wrap documents kind of meet two functions or two purposes, right? The first one is that it wraps the carrier documents, or if you have a self-funded plan, potentially whatever self-funded plan documents you got from your TPA, with the necessary information to create a health and welfare SPD. Okay. Now, mind you, whenever you have a DOL audit, that SPD for a health and welfare plan is really going to be the number one, document that they're going to want. But as we mentioned, what you get from the carrier is generally never the SPD. Okay. And I just want to drill that into your head because I think a lot of, like I said, you might even get a document from the carrier that says SPD that does not actually meet those requirements. Okay. And as RJ talked about a little bit earlier, we know for a fact that a lot of those documents are missing these specific pieces of ERISA required information that identify the plan. Okay. And so the expectation is that you're going to have a document that quote unquote wraps the carrier documents with the necessary information under ERISA to be an SPD. Okay.
And now the second purpose for the wrap document is to ease administration. With a wrap document, you have one wrap document versus several. You have one plan number versus several plan numbers, and therefore you only need to file one Form 5500 filing versus several Form 5500 filings. And remember that ERISA applies to more than just medical benefits. It applies to the benefits that you see right in front of you: medical, dental, vision, HRA, health FSA, group long-term, group term life, group disability, most EAPs, and some business travel plans. And what is the required content of wrap documents? Basically, the same information and content that you would find in a single plan document or a single SPD, but applied to multiple benefits. Now, this next part in red ink is very important. The SPD is not complete without the wrap plus all of the carrier certificates plus any summary of material modifications if you have them. And who must receive these documents and by when? It's really just, again, the same thing. These distribution requirements are the same as the single plan document and SPD. And moving on to some of the wrap document common compliance pitfalls, we have a big compliance issue, plan year versus policy year. So all benefits must be on the same plan year in order to be wrapped together in the same document. And to give you an example, we, for instance, could not wrap together a medical benefit and a vision benefit where the medical runs on a calendar year plan and where the dental benefit runs on a fiscal year plan, beginning sometime other than January 1. Sometimes benefits have different policy years though. For instance, if the medical and vision benefits have different policy years or different renewal dates, then we would still be able to wrap those benefits together potentially into one wrap document. And a good way to tell if you have benefits that run on different policy years or different plan years is to check how many open enrollments you have or how many open enrollments you provide to employees. If you only have one open enrollment and you allow your employees to elect all benefits during that time, then the benefits likely all have the same plan year and you're okay to wrap those together. But if you have more than one open enrollment for multiple benefits, then they likely have different plan years, in which case you would need to have a different ERISA plan document and a different ERISA plan summary plan description for those different benefits that have different plan years. They would also have to have different plan numbers, and you would need to file multiple Form 5500s if you are an employer who has 100 participants or more. And
now, I thank you, RJ, for that information about wrap documents. And I know that some of you are probably listening to this, and at this point in the conversation, your head is spinning a little bit, okay? We totally get it. Part of the reason why you work with a company like us is that we kind of try to help you keep track of kind of what's required and what it means in your specific situation, okay? So for many of you, your advisor will be able to assist you in figuring out kind of what documents you have, what documents you don't have, and what you need to do to be in compliance. One final thing I'll mention as far as wrap documents when it comes to self-funded plans is that we've been talking a lot about the idea that the wrap plan document or wrap SPD can wrap the carrier certificate. But obviously, if you have a self-funded plan, that might not be called and likely is not called the carrier certificate. We've seen it be called a schedule of benefits or a booklet. Some self-funded plans might have the information you're looking for in the actual ASO agreement. It really just depends. But what you're really looking for is the document that goes into the treatment and benefits that are covered under the plan, as well as certain things like, how you would appeal a claim, and information like that. And so it's one of those things where you might have a couple documents that you have to review to know which ones need to be wrapped with that wrapped SPD. Okay, so thank you for that discussion of wrap documents, RJ. We're going to end out with a discussion on distribution methods because we did get a decent amount of questions on that. Okay, so first of all, let's just talk about kind of what your options are, right? Mailing, although I don't think that's ideal for most because these SPDs and plan and things can be really long, right? And so having to print out paper and mail that can be a process, but it is, since ERISA was started, the main way that you can prove that you sent something in compliance with the DOL's rules, and that's to mail it. Okay, so that is still the case. If you're going to mail it, obviously you want to document that process. Some employers take an additional step and might do, let's say, certified return receipts. I will tell you, as someone who used to be a DOL investigator, generally it was enough if you just, at the time that you mail these, made a list of all of the people that you mailed it to and dated it, right? Like it didn't have to be too, crazy. And as long as we didn't have employees who were saying they never received their SPD, they would usually kind of trust you with that. But keep in mind, there are also ways through the mail system to specifically document when you've mailed what, okay? Another option is to hand deliver these, okay? Now, mind you, I will always say that plan participants and working with them can be such that you gave something to someone yesterday, and if it benefits them, they will say that they never received it, okay? And so you wanna make sure that if you are going with hand delivery, that you get an actual signature saying that they have received it, right? That's going to be the best case scenario is if hand delivery is what you're going to do. And there are some industries where hand delivery is still the best method, especially if you might have employees who, let's say, are coming into the office to do things like check in, or maybe coming in, let's say, in a factory into the break room. And might have to sign off. That might be the way to go, okay? Third, and what we've gotten the bulk of questions about as far as it pertains to distribution, is the idea of giving it out electronically. As I mentioned, we all have, these basically powerful computers in our pocket, and you can give things to people in any number of electronic ways. It used to be email was what we were most used to, but now we're talking about things like intranets and even apps, and making that information available electronically. But it's important that if you're going to do electronic distribution, that you realize that there are specific rules that the DOL has in place for electronic distributions of these documents. Now, on the retirement side, they made it a little bit easier because they made it to where electronic distribution can be the default, but they did not include health. And we don't necessarily have any indication that they are going to include health because they have a few more important things going on right now, I think. But keep in mind that for the time being, you're still going to want to comply with the DOL's electronic disclosure rules. And I want to take just a second to explain those so that you kind of understand, okay? This is actually a graphic that Jill Brooking made, our moderator, who I'm going to call on in a few minutes to find out what questions she wants to talk about. But the point is, you want to think about it kind of in just 3 different steps, basically. First of all, the first question is whether or not your employees have electronic access as an essential part of their job or an essential job duty, okay? And I want to stop there and kind of share with you what that means, okay? Because a lot of employers might say, well, my employees have an occasion to stop by a computer at some point during the day. Does that count? It does not count. When you think of this first group of people who has electronic access as an integral part of their job, those are people who literally work at computers all day long. Those are people like us, at NFP. Those are consultants. Those are probably accountants. Those are not people who, let's say, do construction. Those are not people who, let's say, wait tables. If they're not doing a bulk of their job at a computer, then they don't fit in that group, okay? Now, if they do fit in that group where they're working at a computer all day, then you can send them things electronically, subject to a couple of other rules, okay, that we'll talk about. But if they are not in that first group, then you have to ask their consent, okay? And basically, if they're kind of in that group that doesn't have computer access as an integral part of their job, then you want to get them to sign off and say, yes, you can send me things electronically. Now, employers approach this a couple different ways. Some employers will say at open enrollment, hey, can you, give us your consent to provide these documents electronically? Some of them do this upon hire for employees, when they're giving that information about the plans, and they'll say, look, we intend to send you these documents electronically. Do you consent to that? And then that person gives their consent. The good thing is consent can somewhat be evergreen, right? So you don't have to ask them every year for their consent. Basically, their consent is in place until they snatch it back, right? And if they tell you, no, I do not want electronic documents, then you do need to provide them in paper, okay? So you want to make sure that you're taking that step to first identify your groups of employees, and then also make sure that you're requesting consent for the ones that you should be doing that with, all right? Now, let's talk about the idea that, okay, we have a bunch of employees in group one who work at computers all day, and all of our other people who don't work at computers gave us their consent. What do we have to do there? There we have to also make sure that the access to the documents is made appropriately, if you will, okay? And so the important thing there is you don't just want to upload it somewhere. You want to make sure that they actually know it's there, right? The DOL and the regulations are interested in actual receipt of the documents, because if the person did not actually receive them, then likewise, then there's a chance that they don't know what benefits they have under the plan and what the rules are. And so in our current world of electronic distribution, what that's going to mean is that depending on how you provide it electronically, you may have to take additional steps to, let's say, send them another communication. So a good example, first of all, is email. You can do emails and email them the document and attach the document, okay? Then they just got it, right? You generally have to give them the document. It's a good idea to say, hey, this is what this document is. This is why it's important. And if you want a paper copy, you can ask for one, okay? But some of you asked about placing this document on an intranet. Okay, which is also an option as long as you can do that. However, it takes additional steps, because if I, as the employer, put a document on an intranet today and I don't tell anybody I did it, then there's an argument that they didn't actually know, they were not notified that they could access it. So if you're going to put it on something like an intranet, then you need to take another step, whether it's a postcard or an email, to say, look, we provided your SPD on this intranet, go here and find it. If you want a paper copy, you can ask us, right? So it's this whole idea that the DOL wants to know for sure that no matter how you, quote unquote, distribute the documents, that the person actually knows that they've been distributed to them. Okay, so that's kind of what those rules are, but just keep in mind that a lot of employers kind of live in this space where they might not have actually gotten consent from people who don't work at computers all day, in which case you'll want to engage in doing that as soon as possible. So just some final thoughts before I think Jill will have maybe 5 minutes or so to kind of maybe kick off some Q&A or discussion. Final thoughts, having plan documents, we talk about it from the standpoint of the compliance requirements. And I think it's easy to look at compliance requirements as kind of a check the box type thing, like, did we do it or did we not do it? But it's important to note that plan documents are also there, and you want to provide them and make sure that they're correct to make sure that you're meeting your fiduciary duty, as well as protecting yourself and your plan from additional liability. The different documents meet different requirements. If you don't have documents, then there's always the concern that if some, employee or someone were to sue you and question any of the terms of your plan, if you don't even have documents, then you're not in the best position to be able to defend what your plan terms were, right? And so knowing the differences between the documents and when they should be used and when they should be provided is really part of your fiduciary duty. I'll also mention that we talk specifically about some of these documents that we have specific names for in the code or in ERISA, but really all of the documents that you provide can be kind of brought into a court of law to be used against you. And I'd like to bring that up because some of you might have asked a couple questions about, for example, benefit enrollment guides or other documents or notifications that you give to employees. And the biggest thing there is you want to make sure that those documents are not conflicting with the official plan documents. Now, often your official plan document or SPD are going to say or have language to say, hey, this document is controlling over anything else. But you don't want to be that employer that's in a courtroom and having to defend the idea that your participant understood one thing and the plan documents reflected something else, right? You're just not in a good position. And we have quite a bit of case law that's going to lean towards kind of protecting that plan participant if you communicated something incorrectly. So you just want to make sure that you're really kind of being mindful of that. I will also say that we focused a little bit less on the entities that are providing these documents for you. And I would say that you want to be careful here because not all plan document vendors are created equal. I think a lot of you, if you have like a simple plan, most of your plan document vendors can kind of accomplish that for you. But I definitely think that once you start talking about complex plan designs, you're going to want to make sure that the vendor that you're working with understands the differences and what that means. So for example, if you have a multiple employer welfare arrangement, if you offer retiree coverage, language. If you have multiple unions, or multiple collective bargaining agreements that your employees are subject to, then you likely want to go with a more sophisticated vendor, okay? I will also say that no matter who your vendor is, I guess unless your vendor is also your ERISA attorney, that it's a good idea to have an ERISA attorney review that document as it was created by your vendor. Just because generally a lot of the vendors that are in the space are not saying that they are your attorney. And so they are not necessarily vouching for this as your legal plan document, as much as they're saying, okay, we're going to provide this to you based on what we understand the provisions of your plan to be. And we're going to use a template usually to kind of provide the language that we know ERISA is looking for. Okay, so it's always a good next step to have an ERISA attorney actually review that. And then lastly, again, there might be some of you in today's conversation who are like, okay, I know for a fact I don't have a cafeteria plan document, or I never have, or I can't put my hands on it. Where do we start? And I think the biggest thing is just like, if you don't have it, go ahead and start working towards getting it, right? To kind of put you at ease a little bit. Generally with the DOL, if they catch you not having a document, they're going to make you get one. Right. So it's a matter of whether or not you want to do it on their timing or yours, but keep in mind that you don't want to be paralyzed by the idea that, okay, we haven't had these documents, or, we don't know where they are, or they're old. You want to work with your NFP advisors and consultants to just go ahead and start the process for getting those plan documents in place. So Jill, what do we have? Anything interesting?
So in the I changed my question in the last few minutes here, because we have gotten an interesting one here at the end. We provide the SPD as a memo with a QR code linking to the actual document. Is this acceptable? So my first thought is the agencies have said that a QR code on the new ID cards for transparency purposes are acceptable, but this is completely different, and this has been around a long time, so I'm interested in hearing your thoughts.
Yeah, so that's interesting. I will say that generally the industry and kind of even employers just move quicker than the government, frankly. And so we have some guidance, especially with electronic disclosure, that kind of laid out a list of the different types of electronic disclosure that's available. It's from like the early 2000s, frankly, and included things like a CD. And I don't even think my laptop takes a CD anymore. But I say all that to say that the DOL and the government generally are behind. Okay. So I don't know that they have specifically brought up a QR code. And so, yeah, Jill, I would just obviously proceed with caution, but also just make sure that if you're going to do that everything else is kind of in place. So you've gotten the consent from people if they don't work at computers all day. Part of, let's say in the memo, it says, look, we're providing you this SPD through this QR code. If you want a paper copy, you can ask us for it. You just want to make sure that you're taking those additional steps that we know that the electronic disclosure provisions would require.
Agreed. I like that answer. So we have 1 minute left. So thank you. This was really, really great. And some good questions were asked, and hopefully everyone saw those answers posted, because they do post publicly when you ask them, unless you say private. So hopefully you saw those. And before I turn it back to Amber, I just want to say I had a blind date, or a first date, not exactly blind, but first date a couple of years ago. First date, he made me a mix CD. And I'm like, what is this, 1998? And so, yeah, CDs are not good for first dates, and they're not good for SPDs either. I will close on that.
Thank you so much, Jill. Amber, you want to do our outro?
Amber, your turn.
Thank you, Beth and RJ, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete this survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.